This section of the resource is designed to provide a very brief introduction to the sources of law and to the Scottish legal system, which exists as a separate system with many differences from the rest of the United Kingdom. These differences include a different court system, differences in the legal profession, as well as differences in other areas of law, some of which we'll look at later on. Until 1707, of course, Scotland had a separate parliament and legal system from the rest of what is now the United Kingdom. And in that time, the law in Scotland had, in a number of ways, developed differently from that in the rest of the UK. Examples include the law about property, the law of contract, succession law, and the law about what we would now describe as adults with incapacity. As part of the Act of Union of 1707, which unified the Parliaments of Scotland and England, protection was given to Scots private law, which is essentially the law about relationships between individuals, including corporate individuals, and this includes, for example, family law and the law about adults with incapacity, and this protection preserved these differences for the future. After the Union in 1707, and until the new Scottish Parliament was created towards the end of the 20th century, Scots law relevant to social work practice developed in two ways. First, entirely separate development. For example, mental health law, the law about adults with incapacity, and much of the law about children and families is entirely separate from the law in the rest of the United Kingdom and is quite different from it. Secondly, identical provision. In some cases, the same piece of legislation applies throughout the United Kingdom. Relevant examples are the Human Rights Act and the Equality Act of 2010, which give the same rights across all of the United Kingdom. In other cases, the same rules were introduced but are part of different pieces of legislation. One example is the law relating to community care. When this was introduced in England and Wales, the legal basis was the NHS and Community Care Act of 1990, which has now in fact been replaced by the Care Act of 2014. In Scotland, the law was and is found in the Social Work Scotland Act 1968, as we shall see shortly. Since the new Scottish Parliament was inaugurated in 1999, it has had the power to legislate on most areas of concern relating to social work practice, allowing for independent legal development and for increasing divergence from the rest of the United Kingdom, for example in relation to the law about children. This, together with the point made earlier about separate development, explain why caution is necessary in looking at social work texts written for an English audience and assuming that the law which is stated in there also applies to Scotland. In many cases it won't, the law will be different or it will have a different legal basis. So that's a brief introduction to the legal system. The next question is, where does law come from? The most important source is legislation, and legislation includes Acts of Parliament, whether of the United Kingdom or the Scottish Parliament, and these Acts of Parliament are sometimes referred to as statutes, and it also includes delegated legislation. A more minor role is played by precedent, that is law which is created by the courts, and in practice by guidance from the Scottish Government or other organisations such as the Equality and Human Rights Commission. Let's start by looking at Acts of Parliament. Slide 1 shows part of Section 12A of the Social Work Scotland Act, and I'll refer to that from now on as the 1968 Act. All Acts are divided up into sections, and this particular section illustrates a number of important points about Acts and about legislation more generally. It provides the statutory basis for the carrying out of community care assessments and the obligation of local authorities to take account of these in deciding on provision of services. This has a more general implication. Social work in a public sector setting is only possible to the extent that it is required or authorised by legislation. there must always be a statutory basis for local authority actions and therefore the actions of social workers employed by them. This section was added in to the 1968 Act by the NHS and Community Care Act 1990 and has been amended since then. The part in italics was added by the Community Care and Health Scotland Act 2002 to replace text that was there previously. Legislation is never static. It is common for it to be amended, to have bits added to it or bits removed. The 1968 Act, as it has legal effect today, is very different from the Act which was passed in 1968. Third point is that legislation, whether in the form of acts or of delegated legislation, calls for interpretation. Here, for example, what does it mean to say that someone has a need? And this has been a contentious issue. What are community care services, and what does it mean for a carer to provide a substantial amount of care on a regular basis, and how is any assessment of needs to be carried out? The answers to one of these questions is found in the 1968 Act, which defines community care services in another section. It is common to find terms and phrases defined in legislation, though care can sometimes be needed. The Children's Scotland Act 1995 defines child in different ways for different purposes. Beyond this, help can be found in interpreting legislation in guidance given by the Scottish Government, for example about the process of assessment and how it should be carried out. It should be noted that this guidance does not have the force of law, but courts will still consider it if what the local authority has done or how it has done it is challenged. Finally, some issues about meaning are litigated in court, and judgments have shed light on, for example, the meaning of need and the relevance of local authority resources at various stages in the assessment and decision-making process. Finally, although it is not obvious from the extract, it does illustrate a further point about legislation. Just because an act has been passed by Parliament and been given as required the royal assent, doesn't mean it immediately becomes law. In order for that to happen, it has to be commenced or brought into effect. For example, although Section 12A was passed in 1990, it only came into effect in April 1993. Delays in implementation of new legislation are common. For example, time may be needed to train staff or to set up new administrative arrangements or to make delegated legislation containing more detailed rules. And it's to delegated legislation that we now turn. The first piece of text in slide 2 comes from the Children's Scotland Act 1995. As you can see, it gives power to the Scottish ministers to make regulations about what a local authority's specific duties are in respect of children who are looked after. These regulations are described as delegated legislation. The detail of the rules is not in the Act, but the Scottish ministers are given the power by Parliament to make these rules. In other words, the power to make law is delegated to them, hence the name. In some cases, the regulations will have to be approved, or at least not disapproved, by Parliament. The laws, which are usually described as regulations or rules, made by ministers, have exactly the same legal effect as an Act of Parliament, despite being made under delegated powers. The second piece of text in slide 4 is from regulations made under Section 17 of the Children's Scotland Act 1995, and these are the Looked After Children Scotland Regulations of 2009. As you can see, and as suggested earlier, these provide more detail about the local authority's obligations and are important in putting the Act into practice. Finally, to say something about the other two sources of law that I mentioned earlier. We've already mentioned guidance, and there's a substantial quantity of it in existence across all of the law relating to social work practice. In the area of community care, there is, for example, the guidance already mentioned on assessment, guidance and assessment of carers, guidance in self-directed support, and guidance on free personal care, one of the areas where Scotland diverges from England. Now, as I've said, guidance is not legally binding, but there is an expectation that social workers employed by local authorities will behave consistently with this central government guidance. Finally, precedent. Precedent simply describes the development of rules through court judgment. The reason this has happened is that judges are bound to follow earlier decisions which deal with the same legal issue and which were decided by a court higher up the court hierarchy, and will look at the court hierarchy later on. There are some areas of law which have been almost entirely developed in this way, for example, the law about liability for negligence, but in our context, earlier decisions are mainly useful in providing interpretations of statutory provisions.